if you had the Law and Crime app, or if you're in the chat room on lawandcrime.com, then you would know that I said a surprise, special, stupendous, spectacular, unbelievable brain trust, not only is a talent on air, but off air at the Legal Law and Crime Network is here. I asked if you could all guess who it was, and I am now about to present to you the great, the one, the only, Aaron Keller. Welcome.
I don't know, Bob. You've set such a high standard that I hope I live up to your expectations of me at this point.
You always do. And Aaron, I make no joke about this when I tell people that when I have to do other stuff in the legal world and comment on cases, I go to the Law and Crime Network and look for one of your articles and read it. I read virtually every article.
I'm glad that you're a mouthpiece for my thoughts.
Yeah, exactly.
My spokesperson.
Literally, but as a lawyer, right, you get to lift other lawyers' work, and it's not considered plagiarism. Right?
I guess not. Well, look, I mean, okay, a law professor of mine used to say, look, the law isn't a secret, it's written down. It's a question of recalling it at the right time. It's a question of working with it and knowing how to take law and apply it to a new set of facts.
Right.
That's not really plagiarizing. That's just the application of legal concepts.
So you're saying from now on, when I take the article that you wrote verbatim and put my name on it and take your name out,
no, that's not what I said. That's not what I said. That's not what I said. Stick to your proposition, and I'll stick to mine.
Okay, great. No, it's great to have you on, Aaron. All kidding aside, and seriously, a great, talented writer as well as a guest. That's a hard thing to do both. So, Aaron, I'm really glad you're here and filling in, because there were three things that myself and Judge Wilcott went over, and I want to take a couple of them off and see what your thoughts and feelings are. The first is the fact that we're here at a retrial, or if you will, a resentencing phase on a death penalty case, because the Supreme Court reversed the conviction for the death penalty because the prosecutor in their closing statement had indicated, well, he's serving 2 life sentences now, and if you give him another life sentence for these 2 murders of these 13 and 14-year-old girls, you're giving him a, quote, freebie. And they felt that that had unduly prejudiced the jury. It was a comment that amounted to prosecutorial misconduct. What are your thoughts about that?
Well, look, I think the court in the appellate decision in Kirkland weighed out a number of issues with the way the prosecutor handled the original penalty phase years ago. And it was more than just that. It was speculating about facts that were not in evidence. It was speculating about what the victim went through in the victim's final moments. And of course, look, as you know, as a former prosecutor, it helps to sort of lead jurors through facts through the perspective of one person. But here the court said that the prosecutor went overboard in that. And the court, as you also pointed out, just said, look, the nature of the aggravating circumstances here were, the prosecutor went too far down the line with that. And the prosecutor kind of usurped the role of the jury in deciding what the proper punishment should be, and said, well, if you don't pick this punishment, it's like no punishment at all. That was the one key that a lot of people are honing in on, but it was the decision was actually a broader opinion that really criticized what was going on in that original sentencing hearing.
Yeah, and that's good to know. I mean, because typically what appellate courts will do when reviewing these cases is look at the totality of the statement and what capacity it had to potentially affect the verdict, especially in a death case, because it's the ultimate punishment. And in this particular case, I just want to go back to a tactic that I say all the time to prosecutors. This case has such compelling evidence in it. It is such an obvious death penalty case with such little to no mitigating factors. Don't get on the line. Play it clean. Be passionate, be direct, be forceful, but don't let us have to come back here and victimize the families a second time with another trial.
Exactly. Look, I mean, if you have a strong case, present the strengths of your case. You don't need to go into all these other things if you already have a strong enough case. Don't sit on the line if you can sit back over here and still win. There's no, in other words, let's use volleyball as an analogy. You don't need to be spiking it in the opposing team's face from the net if you can lob it across from way back over here and still win.
Right, and we all know that the number one way that cases will get reversed after a guilty verdict is usually comments that are made by the prosecutor that are considered out of bounds in summation. So it's unfortunate we have to go through this exercise again, but that leads me to the next piece. Me and the judge were talking about the demeanor of the prosecutor in this case. And the judge initially, I was kind of maybe a little different place than she was, felt that he's a little too matter of fact, kind of reading and scripted, and I thought that he was just being more low-key because the facts were driving the case. But at certain points in time, he was showing compelling evidence and just kept reading odd seriatim, as if this was my script and I'm going to go forward with it. And you told me an interesting fact I didn't know off air, that this is the actual district attorney for that county.
This, if I'm not mistaken, from what I saw was Joe Dieters. He's the elected, he's the top dog in that prosecutorial district. That's him. Okay, I think if I understand the original case properly, he's the one that messed it up in the original case. And he's been there for quite a while. He rarely ever prosecutes cases in courtrooms, according to some people I know in that area. So he took this one, and he's the one that got slapped around by the appeals court. So why is he reading off of a script? Because he took that appeals court decision to heart, and he is not going to mess this one up. And, you know, look, a lot of people could turn around and say, well, he's doing this now to try to save face. He's also standing up and basically, without saying it, taking responsibility for doing it the right way this time. You could view it that way. But some of the original comments, yeah, I mean, I think that they went too far. I think the court was correct. What's interesting is the original 2014 decision from the Supreme Court of Ohio found issues with the prosecutor's conduct and then turned around and said, okay, all these issues happened, but it's not enough to flip the case. Then the Supreme Court was asked to reconsider in 2016, and that's when the court reconsidered and said it was enough to flip the case. That's extremely rare for a Supreme Court to decide that it made the wrong decision the first time around.
Right.
I'm only aware of one instance of that ever happening with any of the state Supreme Courts that I follow. That's rare. Two judges basically changed their mind between 2014 and 2016. That's what led to this rehearing.
Right, and you know, as far as execution is concerned, it was probably a good thing that happened, because it's better to go back and retry it, do it clean, because even after they get convicted, and even if it goes through the appeals process, there's all this post-conviction relief thing that can go on for years and years and years if there's a doubt. So when in doubt, go back, redo it if you can, do it clean so that you can get the person executed as quickly as possible. But folks, listen, we're going to be back with Aaron. We could talk again all day about this. I got a couple more questions that I'm interested in asking him. But let's go back to that prosecutor's opening statement, and we'll talk on the other end. Welcome back. I'm here with Aaron Keller. We got 2 minutes, so we're going to just hit this fast. I have two questions for you, Aaron. You were noting before the reasons why the case got reversed, and it was because of comments that he was making that weren't necessarily in evidence. And you were talking about him reading this thing because he doesn't want to make a mistake a second time. And he brought out some really compelling evidence at the last minutes of this girl's life. There's a distinction to be made there, how he's doing it now as opposed to then. What is it?
It's a distinction. It's a fine line, but it's extremely critical. So during the original case, the appeals court had a big issue with the prosecutor talking about what the victim was going through from a speculative standpoint. She was petrified, he said. What feelings did this attack invoke in her? And he's going through some of the facts, but he's trying to lead jurors into the victim's mind and not towards what the defendant did in evidence. That distinction is huge. Now, I know we can sit here and listen to it in sort of an armchair perspective and say it sounds really similar, but the distinction is huge. One is speculating about what went through someone's mind, and another focuses on the defendant's actual conduct from his own words and from evidence from testimony in evidence from the medical examiner.
Right, and that's what you hear him say, and that's what he said, the defendant. That's what he said. He keeps repeating that. And, of course, I think that's more compelling because my old school that I always say, a thought is that the jury likes to convict from the mouth of the defendant more than any other kind of evidence, and that's powerful for him.
Yes.
So, listen, we got a couple seconds left. Overall, prosecutor's opening still effective, don't you think? Because of the facts.
Yeah, I mean, I think that this is more on track based on Ohio law, and Ohio law doesn't allow speculation.
Okay, great. Let's go back and take a couple more minutes, and before we get done, we're going to come back one more time with you, Aaron. Thank you so much for being here. Welcome back. I'm with Aaron Keller, our second guest today, another great guest, and we're talking the Anthony Kirkland case. We're in the penalty phase here. Aaron, you gave us a great breakdown of the reasons why it was reversed, and we're back here, i.e. talking about victim impact that was not in evidence versus the prosecutor now being very careful to just get out what the defendant specifically said, which is bad enough. But, you know, we were talking offline about this. There's something peculiar, creepy, and weird about the detail with which this defendant actually gave the police this confession, like he enjoyed it, like a sick, twisted guy.
Oh yeah, I mean, this guy is not the sort of sympathetic defendant that sometimes we come across in some of the cases that we cover here, where we're sitting here saying, you know, I mean, did this guy really do this? What was his reason for doing it? And compare it to the James Coley case, we were talking about that. What's the difference between that death penalty litigation and this one? In this one, you've got a defendant basically sitting down, as you said, and saying and expressing some kind of perverse enjoyment, perhaps, in the acts that were committed, whereas in the Coley case, you've got somebody who, at least during the guilt phase, argued that he kind of flew off the handle. Is Coley at least marginally more sympathetic than this defendant in Ohio? That argument could be made.
Oh, well, I mean, I think he's hugely more sympathetic merely for the fact that
I know we're comparing people who have done very, very bad things.
Sure,
so that's
sure.
hard to do. But if we're to consider that universe, the cases are certainly different.
Yeah, I mean, you got a 1987 killing and burning of his girlfriend. You got him in there for life in prison for killing of 2 other people. You got a 13 and 14-year-old that he's now on trial for. And Collie is different. And again, like you said, they're all heinous murder cases, no doubt. But
let me put it this way: if both juries came back with a death sentence, would I be able to look at it and say there's evidence in the record that would warrant it? Well, legally, yes. I mean, and that sets aside opinions about whether the death penalty is proper and whatnot. Mm-hmm. They both could come back with one, and I don't think that we'd be looking and saying it's a huge miscarriage of the actual black letter of the law. But look at how different these cases are.
Well,
very, very different.
Let me ask you as like a juror, if Collie came back, no death penalty, life without parole, while you may be surprised at that, and I'm not saying that's going to happen, you could hook in your mind some reasons why the jury may have done that. Is that fair to say?
Yeah, I mean, and I just sit here and say, I'm glad that I don't have to make the decision,
right.
Which is what the litigators in the Collie case are saying is, look, there are people in those chairs that have to make those decisions. I'm glad that I don't have to make those decisions because I would struggle with them. They're not easy decisions. They're not light decisions. They're horribly difficult decisions to make. But sitting here and looking at them from kind of a big picture perspective, I can look and say the Coley jury does not have anywhere near the kinds of facts to consider as the Ohio jury.
Right. So in other words, if the Kirkland case came back and the jury said no death penalty but life in prison, I think we would all be in complete shock given his background and the evidence that came out.
I'm rarely shocked these days because I guess the longer I do this, the more I've seen everything. It would certainly be more of a surprise.
Right. So this defense attorney had to give a defense opening in this case. He had to prepare a case. And I have, and never as a prosecutor, even as a defense attorney now, have any problem with person being represented. That's a very, very crucial fact in our system. I don't think we need to tell you that, the audience that, or the people in our chat room that. But I will tell you, I would dub this defense attorney today, given that there's 5 bodies on his client who apparently was arguing about that he didn't like his breakfast and wasn't going to come to court in his death penalty case, probably the lawyer that is the most confounded, sad, and dumbfounded guy in the whole history of legal profession today trying a case in the United States of America, because he's got to be saying, what am I going to do here?
I'm glad I don't have to make the decision that the jury has to make, and I'm glad that I'm not litigating in that chair. I'll just put it that way.
Yeah, so listen, it would be a great opportunity right now, Aaron, to see what does a defense attorney who has the most confounding, dumbfounding, like hard case with a guy who doesn't want to come to court because he didn't eat his breakfast after he killed 5 people. What do you do in your opening statement? Let's take a look. Man, I can't feel anything but pain for this guy. Aaron, if it were me, the only reason I'd be talking about a psychiatrist if I were the defense attorney right now is asking the psychiatrist afterwards, would you help me out a little bit? Because he's got nowhere to go in this case.
He's doing the best he can with what he's got, and that's all he can do. You know, I mean, a lot of people think lawyers are, you know, pulling strings on marionettes and everything. Look, a good lawyer, as you know, and which I know you are, addresses facts honestly. okay, he doesn't have many other places to go here.
Yeah. Well, listen, folks, it's been great being with you. I'm going to be signing off with Aaron. We'll be signing off as well at the Law&Crime Network, a Dan Abrams production. Get the app. Love being here with you guys. I'll be back next Monday hosting from 3 to 5 and 12 to 3 on Wednesday. Of course, you can always follow me at Bianchi ESQ. Thank you very much for those people that were in the chat room that always participate for your great questions. Law&Crime Network. We'll be coming back in a couple of minutes with more story.